Hi, welcome back to Focal Point, AFR Talk. Brian Fisher is my name. I got one thing I need to finish up here. I'm actually sending out a tweet right here in the middle of the program, and I want to tell you about it here in just a second. And this, it has to do, I want to shift gears just a little bit here for this segment, talk about a column that I wrote. Some of this, I'll alert you in advance, you're probably going to find boring. But it's one of those things that's a part of my effort to make sure that this listening audience is educated when it comes to the Constitution. Constitution is our Bible for our political life. Now, don't misunderstand me. It's not inspired like the Bible. We've had to amend it 27 times, haven't had to amend the Bible once. So I'm not saying it's on the level of inspiration. What I am saying is that it is our ultimate authoritative guide for politics in America. Its principles are shaped and founded by the scriptures. And so if we're operating constitutionally, we're going to be in line ultimately with the laws of nature and nature's God. Now, we got the Boy Scout thing is still percolating, and we've got this issue of gay marriage coming up, and that's what I want to talk about here in just a moment. On the issue of homosexuality, we'll get to gay marriage here in a second and talk about the Boy Scouts. The piece here I'm looking at from Washington Examiner talking about interviews with the doctors that treated Adolf Hitler. These are the German doctors. One was by the name of Karl Brandt. The other was Theodor Morell. These were the German doctors that took care of Hitler during World War II. And they were interviewed by personnel from the U.S. Army. The interviewer was an Army interrogator by the name of Hermann Merle. He was a Vienna-born medical technician, and because of his background in medicine, they enlisted him to do the interview. Now, here is what they reported to these interviews. Now, this is just newly discovered information. So the handwritten notes of this interviewer been buried for decades, since the late 1940s. And here's what these doctors said about Hitler. These doctors, the doctors that actually took care of him in World War II and therefore were in a position to know firsthand, not by what they heard from somebody else, but their personal experience providing medical care for Adolf Hitler, is that he was a homosexual and that he was receiving injections, massive injections of female hormones. I have just been beaten from pillar to post for saying that Adolf Hitler was a homosexual, despite the fact that the historical evidence is abundantly clear. He was denied a promotion in World War I because he was caught in flagrante with his homosexual lover in the trenches. He was a brave soldier, but didn't get medals and so forth because of his lifestyle. There are police records indicating that he was a male prostitute on the streets of Vienna. The Nazi Party was formed in a gay bar in Munich, Germany. And now we have the testimony of his own doctors that he was, in fact, a homosexual. So this comes up. This is the Fisher factoid for the day. This is the Fisher factoid for the day. Hitler's own doctors said he was a homosexual. Hitler's own doctors said that he was receiving massive injections of female hormones. Hitler's own doctors. So that question comes up, whether Hitler was a homosexual. There is the answer. His doctors, both of them, said yes, in fact, he was. He was homosexual, and he was taking female hormone injections, 50,000 units. I don't know of what. I don't know how big the units were, but 50,000 units of female hormones. And on the Boy Scout issue, before I jump into, I've got stories here, ABC, about the number of churches now that are pulling out of the Boy Scouts. We're going to probably send another press release out on Monday calling for this massive exodus from the Boy Scouts. Calling on churches to drop their sponsorships, calling on parents to pull their kids out of scouting. And churches are doing it all over the fruited plain. And, the Scouts are trying to defend what they've done on the grounds that, hey, we're not letting homosexual scoutmasters in here. This is just homosexual scouts. We're letting in them. But then I'm looking at a website, onmyhonor.org. Here is an information page, point number 4. BSA, the Boy Scouts of America, their own youth protection videos indicate that 70% of abuse to boys is by teenagers. That's a quote from the Boy Scouts of America. Their own youth protection video, it's a quote from one of their youth protection videos. The Boy Scouts of America say 70% of abuse to boys is by teenagers. So what are they doing? They are allowing teenagers, teenage homosexuals, inside the tents of 11-year-old Boy Scouts. And we did some poking into the typical camping arrangements, and those of you doing scouting maybe can verify this when we go to the phones in the next segment. But the typical sleeping pattern is 2 boys to a tent. And there aren't any age restrictions or any other sort of restrictions on who gets to sleep in the same tent with whom. So you very easily could have an active 17-year-old homosexual male in the same tent with an 11 and 12-year-old boy, when the Boy Scouts themselves say that 70% of abuse to boys is by teenagers. So in other words, parents, get your kids out of scouting immediately, if not sooner. Now, I wanted to talk a little bit about the upcoming Supreme Court ruling on DOMA, the Defense of Marriage Act, and Proposition 8 in California. Now, you may have heard this expression thrown around. There are a lot of people that say, well, the Supreme Court has got to uphold the legitimacy of gay marriage because of the full faith and credit clause in the Constitution. A lot of people use that. Well, you got the full faith and credit clause. If you got a marriage in one state, it's got to be recognized as a marriage in another state. So the full faith and credit clause, the Constitution requires that one state honor and recognize a marriage license that is issued in another state. That marriage license has to be given full faith and credit. You got to honor it. So a homosexual couple gets married in Massachusetts. They move to your state. According to this view, you are obligated, your state is obligated, no matter what your domestic policy is, to recognize that as a valid marriage, full faith and credit. Now, I don't know how much that played in the court debates, but I want to give you a very clear understanding about the full faith and credit clause, that it does not, in fact, mandate gay marriage. The full faith and credit clause does not mandate gay marriage. And there are several reasons for this. Number one, it's very clear from the Federalist Papers and from the Constitution itself that the full faith and credit clause deals only with judicial decisions, judicial acts, and not legislation. It deals with the courts and not legislatures. It concerns judicial decisions and not public policy. Here's how that part of the Constitution reads. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. Notice the phrase judicial proceedings. And it has to be given full faith and credit. Now, this is why, for instance, if you live in Kansas and a court in Kansas, again, we're not talking about the law here, legislatures, we're talking about court actions, court decisions. If a court in Kansas says you owe money to a creditor and you got to pay up, you cannot run from that by fleeing to Kansas. Because Kansas is obligated, or Missouri rather, if you're in Kansas and the court says you owe money, you can't go to Missouri and get off the hook, because Missouri is obligated to give full faith and credit to the judicial finding, judicial decision of the court in Kansas. Now, if you're in Missouri and you're found guilty of murder, you can't beat the rap by running to Kansas, because Kansas has to give full faith and credit to that court, that judicial proceeding, and they got to send you back home to face the music. Now, the Congress enacted a law just 3 years after the Constitution was ratified, and here's how that legislation read, and it was based on the full faith and credit clause. The records and judicial proceedings, again, the records and judicial proceedings shall have such faith and credit given to them in every court within the United States as they have by law or usage in the courts of the state from which said records are or shall be taken. We're talking here about court records. We're talking about court proceedings. We are talking about court decisions. So it's very, very important to understand that. Talking about courts, not talking about legislatures, talking about judicial proceedings, not talking about laws, not talking about statutes. Now, secondly, the court for a long time, the Supreme Court has for a long time recognized a public policy exception to the full faith and credit clause. In other words, they made it very, very clear that the full faith and credit clause does not require one state to accept the public policy of another state if whatever that other state has done is contrary to its own public policy. Here is from a 1939 Supreme Court ruling. Listen to this. Supreme Court now, in the case of statutes, listen to this, the full faith and credit clause does not, I repeat, does not require one state to substitute for its own statute the conflicting statute of another state. So it's right there. I mean, that's as plain as the nose on my face, that if your statute in your state says we will not recognize gay marriage, contrary to our public policy, we've even got a state constitution that prohibits it. The Supreme Court itself said a statute of another state, so what if Massachusetts permits and recognizes gay marriage? That has no relevance to the domestic policy in your state, and you are not obligated to accept the state policy of Massachusetts, the statute in Massachusetts, if it conflicts with your own statute. So I think that's very, very important to know. A couple of quotes here from legal experts. This is Patrick Borchers of Creighton University School of Law. Here's what he said in his abstract. He examined this issue. Listen to this. States have always retained the power to refuse to recognize some out-of-state marriages that violate their expressions of public policy. This has happened with, for example, marriages involving underage spouses or marriages that violate a state's consanguinity rules. That is, in some states you can marry a first cousin, other states you can't. And no state that has those consanguinity rules is obligated to defer to a marriage that's performed in another state if it violates their own policy. Here are two Yale Law School professors. Long-standing precedent from around the country holds that a state need not recognize a marriage entered into in another state with different marriage laws. Focal Point, AFR Talk.